get started. Welcome everybody to another lunchtime CBLS seminar. Today our seminar is going to be on contempt of court. I'll talk about that more in a minute, and our presenter. I want to take care of a couple housekeeping issues, so make sure everybody signs in. That way we can give you a certification for CLE credit. I want to remind everybody also that all of our seminars are recorded and archived. You can go back and watch them not only for fun, but for MCLE credit now. So our seminars and sessions archived back to July of 2011 can all be viewed as long as you're doing it for the first time and receive MCLE credit from the archive seminar. So feel free to go on our website to do that, cbls.org, or illinoislegaladvocate.org or illinoisprobono.org. Next month's seminar is on June 28th, and it's on advanced guardian ad litem issues and adult disabled guardianship cases, and it's being given by Paul Franciscowicz. That should be an interesting one on June 28th. Today we have contempt of court. I think it's a great topic. I love being able to pursue a contempt finding, but I also have been in many cases where it's been pursued against my clients, so you kind of have to understand both sides. Today we have Jerry Brown. Jerry's an adjunct professor at John Marshall, right? Also in private practice, is a good friend of CBLS, and he is our speaker today on contempt of court. So let's get started. Thanks, Jerry.
Good afternoon, everyone. Rather than waiting to the end for questions, just jump in with questions whenever you have them. I'll do my best to answer them. I've taught remedies at John Marshall going back to 2003 and spent a lot of time talking about contempt. It's an issue that I've encountered frequently in litigation, and it's surprising how many gray areas there are in the law of contempt. I think it is a critical area for lawyers to know well. I mean, one of the biggest practical concerns with the law of contempt is, particularly if you're in litigation, you have an obligation to represent your client vigorously and zealously, even if the court or the judge is not happy with or disagrees with your argument, and simply annoying the judge shouldn't put you in fear of being tossed in jail or fined hundreds of dollars. So we really need to understand what is the law of contempt, what are the limits in terms of what you can do in terms of representing your client, and what the court can do in terms of preserving its ability to function and its decorum throughout the litigation process. I do have a fairly lengthy PowerPoint. My bigger concern in preparing is for you to have what might be a usable reference beyond today, so I may zip through certain portions of it rather quickly, but again, if there's any point in which you have a question, feel free to just jump right in. The contempt power is an inherent power of the court, and by inherent, I mean it exists simply by the court's very creation and existence. It exists over and above any statutory expression of the contempt powers that the court may have, and it's viewed as a power that is necessary, in fact indispensable, to the courts being able to function and exercise its other powers and responsibilities. Primarily, it's viewed as a power necessary to enforce order and make sure that parties behave in a way that allows the court to function. This is both recognized at the state and federal level. One case that I've taught several times in my remedies course that helps clarify one of the issues in terms of the limitations of the court's contempt power involved United States versus Hall. This is a case that involved a school desegregation consent decree, and a parent of one of the children that was attending the school that was subject of the consent decree disagreed with the issuance of the consent decree and did things that obstructed the application of the decree, and that parent, Mr. Hall, was cited for contempt. He sought to defend the contempt citation by pointing out that he was not a named party to the consent decree. He had never filed an appearance in the case. He had never been heard during the actual litigation. So under Federal Rule of Civil Procedure 65D, which limits, by statute application of decrees to parties to the proceedings or those acting in active concert or participation with the original parties. He says that he's therefore not covered by the decree and he therefore could not be held in contempt. The court ruled, the Fifth Circuit is, that even though Hall was not a named litigant or acting in active participation or concert with the other parties, the court had the power to make its ruling broadly applicable to the community at large because it was necessary for it to do that in order to preserve the status quo and to preserve its ability to meaningfully adjudicate the dispute. So even though Federal Rule 65 listed the parties against whom ordinarily a court could make an injunction or its order enforceable, when it came to the court's inherent authority, the court ruled that Rule 65 was not a limitation of its authority. It was mere an expression of certain components of the authority, and that the legislature could not, by statute or rule, limit the court's inherent authorities. So for that reason, even if you see a statute or a rule that purports to list certain elements of the contempt power, that would not constitute a limitation of the court's inherent power. Also, the courts, this is particularly so at the federal level, they may use their inherent powers to punish parties who abuse the judicial process. And again, even though there may be statutes that list certain elements of punishment that the court may mete out to enforce its power, the court's inherent powers go beyond those statutorily designated powers. The case cited here is Chambers versus NASCO. In this case, you had parties, they were litigating a real estate transaction, and the plaintiff sent a notice for a preliminary injunction to the other side. They sent the notice out on a Friday to be heard on a Monday. So in anticipation of the proceedings to take place on Monday, the defendant then rapidly engaged in a number of expedited transactions to put the property at issue beyond the reach of the court. In other words, they sought to defeat the court's ability to litigate the matter, and they engaged in a number of other activities throughout the litigation to frustrate the court's ability to hear the case. So at the end of the case, the court cited the plaintiff and imposed roughly $1 million in attorney's fees for their activities that sought to frustrate the court's ability. And there was no statutory basis for this. This was done based on the court's inherent powers to preserve its ability to ensure that the court proceedings function properly. Unlike federal court, Illinois law does not allow for compensatory damages to be awarded in the context of a civil contempt proceeding. At the federal level, compensatory damages may be an element of damages in a contempt proceeding, so it's a more important distinction. Illinois courts have ruled that it is simply without the authority to compensate an aggrieved party for damages, that would be more probably be the focus of a separate civil claim against the offending party. So the federal courts, whereas they view themselves as having the inherent power to punish and make damages part of that sanction in a civil contempt proceeding, at least in Illinois, the courts have not viewed that as part of their inherent authority. So it's one critical difference to keep in mind if you're litigating in state court rather than federal court. Both state and federal courts allow for attorney's fees for civil contempt proceedings. Let's discuss the two of the main categorizations of the law of contempt. One distinction is between criminal contempt and civil contempt. Civil contempt aims to bring a party into compliance with a court order. An example of a civil contempt sanction would be, for example, if someone's subpoenaed to testify, whether in court or a grand jury, they refuse to do so. They can be jailed for civil contempt, and their civil contempt incarceration would end when they agree to testify. This often comes into play with reporters who will cite the First Amendment as I refuse to give up, testify as to my sources, and so they'll be jailed. And when they agree to testify, their incarceration is ended. Uh, so that would be an example of a civil contempt sanction. Interesting when it comes to trial proceedings or grand jury proceedings, once the proceeding has ended, the incarceration would have to end, because once the proceeding ended, it's no longer possible for the party to comply with the order that to give testimony. Criminal contempt, on the other hand, does not aim to bring a party into compliance. It seeks to punish a party for an action that has already taken place. So the nature of the sanctions differ. The sanction in criminal contempt has to be commensurate for the magnitude of the violation of the court's authority. And again, for civil contempt, the aim has to be what's reasonably calculated to actually bring a party into compliance with a court order. The distinction in the law of contempt is between indirect and direct contempt. Direct contempt is a contempt that takes place in front of the court, where the court has actually seen what has happened and no other fact-finding is necessary for it to impose a sanction. Indirect contempt is an action that has taken place outside of the court's presence and requires additional fact-finding for the court to impose a sanction. One reason this distinction is critical is for a direct contempt, the court will often issue a summary contempt sanction, simply citing the parties right then and there. For an indirect, because there's a need for fact-finding, it will almost always involve a hearing to prove up the necessary facts before there can be any sanction imposed. To find a party in contempt or an indirect contempt, you'll need to prove that there's the existence of a court order and a willful disobedience of that order for finding of indirect contempt. Whether a party is guilty of contempt is a fact question for the trial court, and it won't be disturbed on appeal unless, yes?
On a direct contempt, since it kind of happens right then and there, is there a way to appeal it?
You can appeal a direct contempt, and I'll go into the issues of an appeal a bit later, but just very briefly, since you do raise it. The problem of appealing contempt is until you have a final order, you ordinarily cannot appeal contempt. So the question is the order employ a final order, or is it viewed as an interlocutory order? The lines have been blurred a bit, particularly in Illinois, where discovery orders, while they've typically been viewed as interlocutory, Illinois actually allows for you to appeal them once a contempt sanction has been imposed for a violation of a discovery order. So the critical issue is this a final order? And if not final order, will the court give you language permitting an appeal of that order? The explanation as to why Illinois courts allow for discovery orders to be appealed, actually I've run into at least one appellate judge who strongly disagrees with that, but the cases keep coming down saying that if you can get a contempt order, you can go ahead and appeal a discovery order. An interesting distinction is at federal court, discovery orders as to third parties are appealable, whereas against the litigants themselves, they typically do not allow for getting the contempt order and then bringing it up on appeal. Appealing a direct contempt order, again, it depends on the magnitude of the sanction. If it's a fairly minor sanction, it usually won't be worth the effort of appealing, but there can be circumstances where a party may decide for a variety of reasons that it's worth the effort of actually appealing the direct contempt citation. So again, the critical question, is this a final order, and or will the court grant Rule 304 language to allow for an appeal of the order? One interesting example of the distinction between a direct and indirect contempt arises in the case of the Federal Trade Commission versus Kevin Trudeau. I don't know how many of you have ever seen Kevin Trudeau's infomercials over the years. Well, the FTC has, they don't like his commercials very much. They view them as a violation of the law, and they have brought a number of proceedings against Kevin Trudeau. And after one of these proceedings, in which Mr. Trudeau was fined a rather hefty amount, Kevin Trudeau, it was alleged, sent an email to his numerous supporters asking them to email the judge, voicing their disapproval of the sanction against him. And the judge was Judge Gettleman over at the Dirksen building, and apparently in a day and a half, over 300 emails went to his court computer. He notified the marshal that he was getting this flood of emails, and apparently they thought it necessary to do a threat assessment to see whether the judge was actually in danger. So the judge then summoned the attorneys and the parties to the court the next day and cited Mr. Trudeau for contempt, and he concludes that this was a direct contempt because he was a recipient of the emails that gave rise to the contempt sanction that he issued. Kevin Trudeau appealed the contempt sanction on the grounds that this was not a direct contempt, it was an indirect contempt, and because it was indirect, the judge could not issue a summary contempt sanction. And the Seventh Circuit agreed with Trudeau that even though the judge had received the emails, at minimum he needed to have Mr. Trudeau confirm that he had in fact ordered or requested his supporters to send the emails to the court. So for that reason, that minimal level of additional fact-finding in this view of the Seventh Circuit made this an indirect contempt, which would require a hearing rather than a direct contempt, which would have allowed for a summary imposition of a contempt sanction. The court rejected the argument from the FTC that, or the court, that the court's presence should be understood as being beyond the physical confines of the courtroom. The opinion makes reference to Federal Rule of Criminal Procedure 42B, which outlines the standards under which parties can be held in criminal contempt. The sanctions that can be imposed for criminal contempt usually almost always come down to either incarceration or a monetary fine, and they're done for the purposes of ensuring that judges and court officials are shown respect, that judicial proceedings are conducted in an orderly manner, that court orders are obeyed, and that individuals are not permitted to commit fraud on the court. These standards are pretty much the same at both the state and federal level. One issue that comes into play is whether a violation of an order must be willful in order to support a contempt finding. Ordinarily, to find a criminal contempt, you do need a showing that the order has been willful. For civil contempt, that typically is not necessary. The court will look more as has there been sufficient diligence in the respondent's efforts to comply with the order. One thing to keep in mind, if you're representing someone who's subject to a court order and that person comes to realize that he or she is not able to comply, the question is, do you just wait until the order's been violated and then hope to raise your client's inability to comply as a defense, or should you then go to court and ask to have the order amended, citing the fact that your client is no longer able to comply with the order. Courts strongly prefer that you actually bring to their attention your client's inability to comply with the order. Your client's in a much better position if you raise it beforehand and the court actually recognizes your client's inability to perform and agrees with it. That would certainly do a much better job of protecting your client from a subsequent contempt sanction. You would then, otherwise you face the argument, if your client knew he or she couldn't comply, why didn't you come to us and raise this issue? An issue does come into play when the civil contempt sanction is no longer capable or likely to actually achieve compliance with a court order. I gave the example of someone who's subpoenaed to testify at trial or to a grand jury. Once the proceeding is over, at that point it's no longer possible for them to comply, so there's clearly no point at that juncture to keep that person in jail. There are other circumstances in which the court, for any number of reasons, may conclude that this sanction is simply no longer likely to or is capable of motivating compliance with the order, and for that reason the court may then just refuse to continue to impose the sanction. One other example might be if there's a rather large monetary fine against a party. If the party against whom this fine is being imposed is essentially judgment proof, the court's again confronted with the circumstance that this sanction is no longer capable or likely to achieve compliance with the order that's motivating the sanction in the first place. Due process concerns with civil contempt. As a requirement, civil contempt order, it will be vacated as once it's no longer capable of achieving compliance, so that is viewed as an element of due process. And again, with civil contempt, a party can be reimbursed its attorney's fees that are incurred in bringing the civil contempt to the court's attention. One fairly interesting case that illustrates a lot of the points of the law of contempt involves the Chicago 7 trial, which goes back to the 1968 convention, which was famously tried over at the Dirksen building. Here the issues were criminal contempt, but a direct summary contempt. During the Chicago 7 trial, I don't know how many of you had the occasion to study or review the events of the Chicago 7 trial. After the 1968 Democratic Convention, 7 were tried for essentially trying to incite riot at the convention. During the trial, there were numerous verbal attacks made on the judge in the eyes of many, numerous attacks by the judge on the defendants, and it just happened repeatedly throughout the course of the trial. Interestingly, the judge, Julius Hoffman, never imposed contempt on the defendants during the actual trial. Rather, he waited to the end of the trial to impose a number of sanctions against the defendants, which totaled, in some cases, as much as 3 years jail time. To give you an idea of just how extreme some of the patterns of behavior were in the trial, there were numerous cases in which the judge would simply tell the lawyers to shut up, tell the defendants to shut up, and there are a number of cases where the lawyers and the defendants actually shouted at the judge that they were running a sham proceeding, questioning, or the judge actually accusing him of being corrupt. There's one fairly vivid description of the trial in a book, I believe, by John Tucker, titled Trial by Jury, where one of the defendants is addressing the court. The judge orders him to shut up. He refuses to do so. He then orders the marshals to make him shut up and sit down. When the marshals physically take hold of the defendant's daughters who were in the court then run over to try to pull the marshals off of their father. two other marshals then run and tackle the girls in the courtroom, and you actually end up with literally a melee on the floor of the courtroom. I think by any reasonable standard at this point, the decorum of the court process has clearly broken down. But again, no sanction was imposed then. It was done at the end of the trial. And the reason that that was found to be critical is the justification for a summary contempt sanction is to preserve the functioning of the trial process. If you wait to the end of the trial, that reason is no longer in play. And the Seventh Circuit then vacated almost all of the contempt sanctions on the ground that because the judge had waited to the end of the proceeding, they should have, one, had the proceeding heard by another judge, and that there should have been a full hearing rather than the summary imposition of contempt sanctions. And again, that opinion, it is worth reading. It's a fairly lengthy opinion, but it does go to illustrate the problem of judges or attorneys who may not be as confrontational as the attorneys in the Chicago 7 trial. But again, you have an obligation to zealously represent your client, and the mere fact that the judge does not wish to hear your efforts to defend your client and make your record should not intimidate you from doing what's necessary to zealously defend your client. And it's important to keep in mind that even though each of the individual elements of the sanctions against the defendants were less than 6 months in their totality, they aggregated more than 6 months, and because of that, it triggers a right to a jury trial. When the criminal contempt sanction is viewed as being serious, the due process protections of the Constitution for criminal law, they do come into play, meaning that there's a right to a jury trial, there's a right to an appointed counsel. So if a court is looking to impose a sanction of more than 6 months, all of the criminal contempt due process protections do come into play. The standard of proof, the criminal standard of proof comes into play for criminal contempt, that is proof beyond a reasonable doubt, whereas for civil contempt, it's the preponderance of the evidence standard. Among the other due process protections for indirect criminal contempt, the defendant is entitled to have to be advised of the nature of the charges against him, to have the charge definitely and specifically set forth by citation, have an opportunity to answer, to invoke privilege, the right for Fifth Amendment privilege against self-incrimination, the presumption of innocence, and to be proved innocent or guilty beyond a reasonable doubt. A petition for indirect criminal contempt should be titled a petition for adjudication of criminal contempt. Ordinarily, civil contempt proceedings are titled a rule to show cause why a party should not be held in contempt. If someone is seeking to have a party held in criminal contempt, the rule to show cause is not the proper vehicle, rather it's the petition for adjudication of criminal contempt. One fairly interesting and really notorious criminal contempt trial that took place here involved the E2 nightclub a few years ago. I don't know how many of you remember, there was a nightclub on around 22nd in Michigan that was under an order from building court to be closed because of structural defects. And it was unclear as to whether the order required that only part of the nightclub be closed or whether the entire nightclub be closed. Well, in any case, the entire nightclub was open, and for reasons unrelated to any structural defects in the club, you had a stampede at the club and 21 persons were trampled to death. So immediately on learning that there was an order in place that appeared to require the club to have been closed, criminal contempt sanctions were sought against the owners of the club. And the the owners of the club were actually convicted after a criminal contempt trial and sentenced to 2 years in jail. And the trial, they were on appeal. The sanctions were overturned. The principal reason for overturning the sanctions was that the order that was allegedly violated was unclear. At trial, you had a judicial order that said that was unclear as to whether the entire club was to be closed or just the second floor of the club or just the second floor mezzanine. You had the judicial half sheet, which is the judge's notes as to what happened at the proceeding, which disagreed with the actual court order. And then you had the transcript, which disagreed both with the actual order and the half sheet. So you had 3 different versions of what was actually ordered at the proceeding. And the court reviewed, the appellate court ruled that in light of this discrepancy in terms of what was actually ordered, it was impossible to prove that there was a willful violation of a clear court order. So one of the best ways to defend a contempt sanction is to prove that the underlying order itself is vague, it's ambiguous, or it's inconsistent in terms of what it actually required the parties to do. One issue that comes into play with the law of contempt is what's known as the collateral bar rule, meaning that even if a court order is later overturned or found to have been unconstitutional, that in jurisdictions that follow the collateral bar rule, the subsequent overturning of that order is not a defense to a contempt proceeding for having violated the underlying order. This is interesting to compare to the way we treat statutes, for example. If a criminal statute is later found to be unconstitutional, the convictions under that statute are vacated. Not so when it comes to court orders. Among the reasons for that distinction in terms of how we treat unconstitutional statutes as to how we treat a non-constitutional court order is it is viewed as a fundamental affront of the court's authority for the order to be violated. And your remedy, if you believe the court's order to be unconstitutional or just wrong on the merits, is to seek a rehearing of the order or to appeal the order rather than taking the law into your own hands or making yourself the judge of your own case and then violating the order, confident in the belief that you'll be vindicated on appeal or on rehearing. Whereas we simply do not view that the legislature's authorities as somehow suffering an unpermissible affront when a party violates a statute. In fact, it's generally understood that the way you challenge a statute's constitutionality is to violate it and then litigate the matter. In some cases, a court may view a party who is not likely to be prosecuted under a statute as lacking standing to challenge the statute. Many statutes are these days contested through declaratory judgments. Again, a court does have the discretion to rule that there's no sufficient showing that this is enough of an issue that merits hearing under a declaratory judgment. So parties sometimes will violate a statute in order to create the standing necessary to challenge its constitutionality. So that's the most frequently cited reason as to why you have the collateral bar rule, which applies to court orders, but that rationale does not apply to statutes. It's important to distinguish orders that are simply wrong on the merits, meaning that the judge at the trial level applied the law incorrectly or erroneously ruled on the facts, as compared to an order that's void. An order that is void is not merely wrong because it got the facts wrong or the law wrong. Rather, it's typically a question of, did the court act without jurisdiction? A court that is acting without jurisdiction is not merely wrong, it is purporting to exercise authority that it does not have. An order that is entered without jurisdiction is not subject to the collateral bar rule, because again, it's not that the court got it wrong and should its order should be heard on rehearing or on appeal. Rather, if it exercised jurisdiction it simply didn't have, the order is not subject to the protection of the collateral bar rule. One of the most famous cases dealing with the collateral bar rule is the case of Walker versus Birmingham. This case involved civil rights protesters who were demonstrating in Birmingham in 1963. They sought to have a demonstration on Good Friday and Easter Sunday. Immediately before they were to have their protest, city officials in Birmingham got a court order against having any protest without a permit. There was an ordinance in Birmingham, Alabama that required permits to have demonstrations. The order was entered ex parte, and the parties learned about it, I believe, on Wednesday afternoon, and they were scheduled to have their protest on Friday. They decided to proceed with their demonstrations on that Friday and the following Sunday, and then submitted themselves to the court's jurisdiction to challenge the order the following Monday. The court entered contempt sanctions against them of 5 days and $50. The sanctions were appealed and all the way up to the Supreme Court. In a bitterly divided court opinion, which actually we recommend reading, the court ruled that regardless of the apparent unconstitutionality of the local ordinance, the order had to be followed and the contempt sanctions were upheld. The dissenters, in language that comes as close as you're ever likely to see in a Supreme Court opinion, they really come close to questioning the motivations of the state courts in entering the order. They raise the issue that the underlying ordinance is plainly unconstitutional, and they again question the motivation of the state court in entering the order under these circumstances, particularly that it was an ex parte order. The majority rest on the notion that even though it appeared there were constitutional challenges to be made against the ordinance, the parties should have sought a rehearing or an appeal of the underlying order rather than simply violating the order without seeking any further relief from the court. So the case makes it clear that once the injunction is in place, even if it appears to be invalid, it still has to be obeyed. And the court was, the dissenters did raise the question as to whether there was even jurisdiction to hear this matter in light that the state court order appeared to introduce federal First Amendment protections. It's interesting to note that the following year, there was litigation over the underlying ordinance under which individuals had been given jail sentences, as is Shuttlesworth versus Birmingham, and the ordinance itself was found to be unconstitutional the following year by substantially the same Supreme Court that upheld the criminal contempt convictions under Walker versus Birmingham. It's also worth pointing out when it comes to the collateral bar rule, one gray area comes into play when it's with regard to the First Amendment of the Constitution. When an injunction appears to require that organs of the press engage in a prior restraint of publication, courts repeatedly view that as just being flatly unconstitutional and have declined to impose orders that would seek to impose a prior restraint, and in some cases they have refused to sustain criminal contempt sanctions that are based on orders that impose a prior restraint. One case in Illinois, Cooper versus Rockford Newspapers, the site to that is 365 Northeast 2nd 746. in which a newspaper was enjoined from publishing matters about a trial. They did so anyway. They appealed their contempt sanction, and the contempt sanction was violated or was vacated on the grounds that the order constituted an unconstitutional prior restraint of First Amendment protections. In the Supreme Court opinion of Walker versus Birmingham, some of the dissenters did raise the issue that the underlying order did introduce First Amendment rights and simply should not have been entered in the first place and should not be viewed as a basis for sustaining a criminal contempt sanction under those circumstances. It's worth pointing out that not every jurisdiction follows the collateral bar rule. Interestingly, the state of California does not follow the collateral bar rule. The federal courts do, Illinois does, but it's worth, if you're litigating in another jurisdiction, do make a point of finding out whether your jurisdiction actually follows the collateral bar rule. The case of Torrey versus Cochran, it interestingly raises this point in that Johnny Cochran, I suspect everyone here knows who Johnny Cochran is. He defended O.J. Simpson in the famous murder trial in 1995. After that trial, he became one of the most famous attorneys in America. Well, apparently, one of his clients in California didn't think much of the service he was getting from Cochran's law office, and he took to actually protesting outside of Johnny Cochran's office every day with signs questioning the value of the services he was getting. He even held up signs such as, "Don't I deserve the same justice as OJ?" and other things like this. Apparently, California law allows for an injunction against parties who are defaming your commercial services, and they got an injunction against Ulysses Torrey from saying anything negative about Johnny Cochran or his law practice. This was appealed up to the California Supreme Court, and it was affirmed by the California Supreme Court. It was then appealed to the U.S. Supreme Court on the grounds that this statute it violates the First Amendment. You can't prohibit someone from just saying anything at all negative about another person. After the oral argument to the U.S. Supreme Court, Johnny Cochran died, which, among other things, raised the question, did Johnny Cochran's death turn this into a moot controversy? Johnny Cochran's no longer alive to benefit from the order, so does the order still remain in effect, and is there anything left for the courts to litigate? The Supreme Court ruled that Johnny Cochran's death did not moot the controversy. The order remained in effect. So one thing to keep in mind that even though circumstances may appear to moot the controversy that is the subject of the injunction, technically you should go to the court and seek to have the order vacated or amended, citing the changed circumstances, namely that the beneficiary of the order has died. The court ruled that one of the reasons that this was not mooted by Cochran's death is that his estate and his continuing law practice, or his success to his law practice, actually did have an interest in the protection from defamation against Johnny Cochran. So they thought that they ruled that there was a real interest at stake that still deserved protection by the court. So the injunction did not just fall away because of Johnny Cochran's death. It does raise the practical question: if you're representing someone who's subject to an order, the other person has died, they may not wish to pay you thousands of dollars to continue litigating against a dead person. They may conclude that there's nobody left to litigate this, even if we do violate the order. But as a technical matter, if there are successors and interests to that order, it may be wise and in fact necessary to go to the court to have the order vacated or amended in light of the death of the person. It does not just fall away because because of the death of the litigant. Again, another question that comes into mind is who can bring contempt proceedings? Civil contempt proceedings are often brought either by the court itself to vindicate its authority, or the party who is the beneficiary of the court order. And as one of the sanctions that we sought for civil contempt proceedings in Illinois, the attorney's fees can be part of the sanction sought. In federal court, damages as well as attorney's fees can be sought. As I mentioned earlier, for non-party witnesses in federal court, they can appeal contempt proceedings against them. And in Illinois, discovery orders can be appealed as contempts of court. One issue that comes up, and the courts have been inconsistent in how they view this, is whether private parties can litigate criminal contempt proceedings. In other words, ordinarily criminal contempt is brought by the court because the party who is injured by a criminal contempt is the court. The injury is understood to be to the court's authority, and ordinarily, even though a private litigant can bring a petition to the court advising it of the criminal contempt, it's usually the court's decision as to whether to authorize a criminal contempt prosecution and then to appoint counsel. Usually it'll either be the state's attorney, the attorney general, or in the case of the E2 nightclub, the prosecutor there was the city corporation counsel, so that they'll retain private counsel to act as a private attorney general, but it's someone hired and retained by the court for the purposes of bringing the contempt proceeding. There are occasionally cases in which a private litigant wishes to bring the criminal contempt and actually have the counsel for the private litigant in bringing the contempt proceeding. Generally, courts have taken the view that a private litigant cannot or should not be permitted to bring a criminal contempt proceeding for a variety of reasons. The principal two being the ethical concern. One, the prosecutor of a criminal contempt, their interest should be vindicating the court's authority, not seeking to press the advantage of the private litigant who is paying them in the underlying civil proceedings. It's not hard to imagine the unfairness that can develop if you're in civil litigation, the other side wishes to prosecute you or your client for criminal contempt, and then the court is actually allowing them to conduct a criminal proceeding against your client at the very same time that you're involved in in civil litigation. It's not hard to imagine circumstances in which the other side might say, well, can we plea bargain the criminal contempt against you in exchange for a favorable resolution of the underlying civil matter? That's clearly an impermissible conflict of interest. Moreover, if you had a private attorney for a litigant prosecuting the criminal contempt, if that person's actually being paid by the civil litigant, it would seem that they obviously think that there's some advantage to being able to prosecute the other side in the civil litigation for criminal contempt. If they didn't think there was an advantage, why would your client be willing to pay their own money to have you litigating the criminal contempt? So there are occasions where parties wish to have their own lawyer bring a criminal contempt proceeding against the other party. The weight of authority is it should not be allowed. One, because of the almost intolerable tension between the obligations owed to the court and the obligations that the attorney would have to his or her own client. One exception that's been recognized in many states, however, comes in the context of civil orders of protection. many jurisdictions, including Illinois, do allow for criminal contempt proceedings to be brought by the beneficiary of the civil order of protection against the violating party. Among the reasons that this exception has been allowed is one, in many parts of the country, it's been recognized that enforcement of civil orders of protection has often been lax, haphazard, and irregular, and often the orders just go unenforced. And that may be because of lack of prosecutorial resources or the setting of priorities. It's unfortunate to think that in light of the many things that a prosecutor's office may do, enforcing the civil orders of protection may fall on the low end of the scale, but in many jurisdictions, the experience appears to be that they just aren't prosecuted with a great deal of zeal. So by allowing the interested party to bring the criminal contempt protection proceeding, it does make it a lot more likely that the proceedings will in fact occur, and that the parties who are intended to benefit from that protection will actually be able to get them enforced. Again, this is a narrow exception to what appears to be the general case law on allowing private litigants to bring criminal contempt proceedings against other parties, but that appears that exception persists pretty much nationwide. So you don't see much in the way of blanket prohibitions against private litigants bringing criminal contempt sanctions, but again, outside of this narrow exception, if you're on the receiving end of an effort to bring a criminal contempt proceeding prosecuted by opposing parties' counsel, I would resist vigorously, and there's ample case law highlighting the reasons why the court should not allow the other side's civil attorney to also participate in the criminal contempt proceedings against your client. I've gone through all of my printed material. Are there any questions? Yes?
Yeah, you had mentioned instead of doing a petition for rule to show cause, are they out altogether, and instead you always do the petition for adjudication of indirect civil contempt?
If you are seeking to have the court bring a criminal contempt proceeding, the form you should follow, but also keep in mind, the final decision as to whether to bring criminal contempt will be by the court. I've not seen any cases where, for example, someone did a motion to alert the court of facts that would then justify a criminal contempt. But I guess the critical thing is the filing that would trigger the actual criminal contempt proceeding would be titled the adjudication for criminal contempt. So when the court finally decides whether to initiate a criminal contempt proceeding, that should be the manner in which the proceeding is titled. Again, allowing for the exception, if you're trying to enforce a civil order of protection and you're actually authorized to bring it independently or on a private basis, that should be titled as an adjudication for contempt. Also, that's under Illinois law. If you're litigating in another jurisdiction, look to see the specific language that is actually provided. But other than that exception, particularly for civil contempt, what you will typically see is a motion or petition for rule to show cause why this party or person should not be held in contempt. Yes?
Is there any limit to the amount of time that someone could be held rated in a direct civil contempt case where they just refuse, for instance, to answer questions? I was in court today where a judge threatened to hold a defendant in contempt because he would not answer questions under a citation to discover assets. If she finds him in contempt and he says, I'm never going to answer the questions, is there any? Can he be held indefinitely?
Generally, no. I mean, and here's where the court has to make a number of determinations. I mean, the standard for a civil contempt sanction is understood as being, quote, does the defendant have the keys to the jailhouse door? When they decide to testify, they affect, she or he affects his or her own release. If the court becomes convinced that no duration of incarceration is ever going to get this person to testify, and what would cause the court to make that conclusion is a topic for another discussion, but if the court comes to believe that, at that point, it's no longer justifiable to continue to incarcerate that person. One example I've used in my class as someone who's not likely to be amenable to some of the traditional court sanctions, some people who protest really high profile disputes, who have demonstrated a willingness to just sit in jail for years and years, the court may have to conclude at this point that this person is just never going to testify. This just isn't doing any good. So we have to let that person go. I think it is a fact question as to whether you've reached the threshold at which continued incarceration simply is not going to have any likelihood of achieving compliance. Once the contempt sanction, or once the underlying citation to discover assets is no longer pending, then plainly at that point you'd have to let that person go, because there's no longer an underlying order in effect that can be complied with. But is there like a preset number of days after which you just have to let this person go? No, there's not. And there are people who have just sat in jail throughout the duration of the term of a grand jury. Two examples that come to mind. I don't know how many of you follow the Barry Bonds trials or investigations, where his trainer, I think, sat through 2 grand jury proceedings and just sat in jail for their entire duration. And they let him out at the end of the first grand jury. They impaneled the second grand jury. He refused to testify. They tossed him back in jail for the duration of the entire grand jury. But again, once the grand jury's term expired, they had to let him go. Another fairly well-known case, going back to the impeachment of President Clinton, Ken Starr's grand jury sought testimony from one of his former business associates, Susan McDougal. I think she sat through 2 grand juries in jail rather than testify. Interesting, the court never came to the conclusion before the end of the term of the grand jury that this isn't going to do any good, let her go. No, she sat all the way through the term of the grand jury, and at the end of the grand jury, they had to let her go. Interestingly, at the end of that case, the special prosecutor actually sought to prosecute her for obstruction of justice. That is an option where, for your failure or refusal to testify, you can be criminally prosecuted for your refusal to testify. That is an exceedingly rare occurrence, but it is one of the options available. Interestingly, in the case of Susan McDougal, I think the result there was a hung jury, and they did not retry her again. But again, to distinguish, the civil sanction of incarceration for refusing to testify is different from the criminal prosecution for obstruction of justice for refusal to have testified before a grand jury whose term has already run. Again, being mindful of the distinction, if the grand jury is still in effect, you can purge or end your incarceration by agreeing to testify. Once the grand jury's term is expired, you don't get to defend yourself against the criminal obstruction of justice claim by saying, well, I'm willing to testify now. And once the grand jury's term is over, that's no longer an option. Yes?
If you string out not testifying, and then you testify, let's say in the 11th hour, can the prosecution then say, well, we're still gonna, you obstructed justice up until?
No, if the grand jury is still in place or impaneled, as long as you agree to testify before the grand jury is disbanded, you've ended your civil term. I have not run across a case where someone said, because you testified so late in the game that we're going to bring an obstruction of justice proceeding against you. I'm fairly confident that no court would sustain that as long as you testified before the termination of the grand jury. Yes.
No, on the criminal contempt charges, you have a right to a jury trial if it's been over 6 months.
If
But-
the sanction sought against you is 6 months or more, yes, you have a right to a jury trial.
So on a civil contempt where it's a undetermined amount of time, if after 6 months has expired, you're still sitting in jail, do you get to, no?
No, you're not entitled to a jury trial for the civil contempt. The civil contempt is simply aimed at achieving your compliance. And again, the critical factor is, do you have the keys to the jailhouse door? If the reason you sat in jail for 6 months is that you refused to testify, that does not trigger an obligation of the court to now give you a jury trial. One example of the way civil contempt sanctions are fashioned that's fairly instructive. I don't know how many of you have had the chance to litigate in building court. Typically what you'll get is the sanction citing your client with violations of the building code. A sanction may be issued on the first court date. You're then given a date certain by which to come into compliance. If your client comes into compliance, often the fines and sanctions are vacated. So in other words, your client has the opportunity to mitigate or wipe out the sanctions by a subsequent act of compliance. So that's one of the critical ways of distinguishing a civil contempt from a criminal contempt. If there's the ability to reduce or eliminate the sanction by a subsequent act of compliance, you have civil contempt. If the effort is not to bring your party into compliance, but rather to punish, there is no issue of a subsequent opportunity to come into compliance and thereby, eliminate the sanction. And there can be practical reasons why, a public authority may prefer civil contempt over criminal contempt. I mean, in many cases, the real motivation is just to achieve compliance. It's not to throw somebody in jail. And again, if in building court, if they always just brought a criminal contempt sanction, that would mean impaneling a jury and dealing with a higher evidentiary standard, proof beyond a reasonable doubt, rather than preponderance of evidence. So administratively, it often can make a lot of sense to just bring civil contempt rather than criminal contempt. Yes.
I have one.
Yeah.
I'm not sure I completely understand the distinction between criminal and civil contempt, and I guess I would just like to ask an example.
Many scholars complain that if under enough complexity, the distinction between the two begin to vanish.
Right. It seems to me then that criminal contempt and civil contempt are not distinguished by the conduct of the contender or alleged contender. Is that correct?
Right. Mm-hmm.
So it's really more the relief you are seeking against the alleged contender, whether you're seeking criminal relief or civil relief.
Right.
And so your example of the person failing or unwilling to testify being held in indirect or direct civil contempt, having the keys to the jail cell by coming out and testifying at some point. But then can the court decide that that's not working and therefore now I'm going to bring a criminal contempt charge and punish that person for failing to testify?
Well, again, if the proceeding has not ended, up to the point, as long as the proceeding is ongoing, it's still possible for this person to testify. So arguably, the sanction has the potential effect of achieving compliance. So as long as the sanction is aimed at achieving compliance, it's a civil contempt sanction. Once the trial has ended or the grand jury's term has ended and it's no longer possible to comply with the subpoena to testify, you can seek a criminal contempt sanction for obstruction. Again, that's an exceedingly...
Talking about that obstruction charge, that's
Yes.
criminal contempt.
Right.
But you were also commenting, and this is just hypothetical, that that there could be a point in time where you've realized that your civil contempt sanction is not going to produce the result. Maybe the person unwilling to testify is saying, I will never testify. So they're on record as saying, I will never comply. And you've decided as a court that the sanction will not cause compliance. Can't you say at that point in time, this person is not complying, both by their own statements and by your decision as a court to say that this isn't working?
I have not seen a case in which someone was released before the end of the grand jury or the end of the trial on the grounds that this sanction is not likely to achieve compliance, and then sought a criminal sanction against them, saying, well, you've obstructed justice because you didn't testify. Because the response would likely then be, well, you simply gave up on the civil sanction, you let me go before the trial ended. I have a hard time imagining the criminal contempt sanction being sought under those circumstances. I've not seen any cases where that fact pattern has arisen. I hesitate to say that it's impossible, but I would be very surprised to see that take place. Usually it's examples where you might see both criminal contempt and civil contempt come into play. Looking, for example, think of the E2 nightclub case where you have a court order appearing to require that premises be vacated. In light of the fact that 21 people were trampled to death, it's clear why there's the motivation to bring the criminal contempt proceeding. But if there's also an ongoing prospective interest in achieving compliance with the underlying court order, you may also see the continuation of a civil sanction aimed not at punishing but also achieving compliance with the court order, while at the same time bringing a criminal contempt proceeding. And also keep in mind, bringing both civil contempt and criminal contempt, those two being done at the same time doesn't create a double jeopardy problem because they're being sought for entirely different purposes. But if you bring a criminal contempt sanction, lose, you then would be barred from bringing yet another criminal contempt sanction for the very same violation. The double jeopardy prohibition would come into play there.
So I think that highlights the distinction between criminal and civil, which is for the same conduct, you can pursue civil sanctions to coerce compliance, criminal sanctions to punish the conduct.
Mm-hmm.
Then when does it go to the other level? Judge's choice, prosecutor's choice?
When does it go from civil contempt to criminal contempt?
Yeah.
That's almost always going to be the judge's call. Because remember, the violation is understood to be to the court's
right.
integrity and authority. So it's the court making the decision as to whether criminal contempt proceedings should go forth. Again, allowing for the exception of civil orders of protection, which is a statutorily recognized exception that permits for private enforcement by means of criminal contempt. Yes?
Does a direct criminal contempt trigger any due process at all protections?
You're required to notice the opportunity to respond, particularly if it's a summary proceeding. Those protections are somewhat a great deal less than a trial for an indirect contempt. And again, it also depends on severity of the sanctions sought to be imposed. It has to be proportional to the aim sought to be achieved. I mean, if, for example, during a trial, if a witness keeps talking after the judge tells him or her to shut up, being taken to jail for a couple of hours is one thing. A sanction of $3 million for talking out of term is obviously disproportionate. So the sanction should be proportionate to the conduct that gave rise to the sanction and the aim sought to be achieved by the sanction.
Well, we've reached our hour plus, and that's all we have time for. But I would imagine if any of you have continuing questions, you can ask Jerry. Are you willing to stay around for a few minutes?
Sure, I am.
And I want to thank him. That was great. Thanks, Jerry.
One example of a really extreme